Hello, everyone. I'm Randy Bandman, and on behalf of the Entertainment Law section of the Beverly Hills Bar Association, welcome you to today's program, From Blueprint to Breakdown, Lessons from the Unrealized Disney OpenAI Deal, in which Julia Cherlow of Marella LLP and David Shraga, the Media Mediator, will discuss how only 4 months after announcing the first of its kind licensing agreement between Disney and OpenAI has now abandoned the deal, and Disney has withdrawn in tandem. And still, this precedent-setting arrangement has shifted the framework for licensing and attendant AI litigation. Julia Cherlow is a partner at Marella and a nationally recognized entertainment trial attorney who represents guilds, talent, and other IP owners in bet the company disputes. Her practice spans cutting-edge issues at the intersection of entertainment, technology, and intellectual property, including high-profile litigation involving film, television, and digital media. David Shraga is a mediator specializing in entertainment, media, and intellectual property, drawing on more than 20 years of legal experience in Los Angeles. His background includes work as both an entertainment and IP litigator and a senior in-house executive at Miramax and NBC Universal, where he developed deep expertise across film, television, and streaming. Thank you, Julia and David.
All right, Julia Cherlow of Marella, it's a pleasure to be back with you here today. It seems like it's only been a few short months since
David
last
Shraga,
interview.
Media Mediator. I can't believe we're back.
Yeah, I think that the last time we talked about the Disney OpenAI deal just a few months ago, we kind of joked that maybe we would do a follow-up and talk about the implementation and talk about some of the things that we had been discussing and predicting for the deal. But I don't think any of us would have predicted we would have been here today having this conversation so soon.
Not at that time, at least. I did start wondering as the months were passing by in 2026 when there was no rollout of the actual Sora product implementing the Disney IP. But certainly couldn't have predicted it the last time we spoke.
So maybe we can set the stage for folks and talk about sort of the big picture, where we left off and sort of why we're back here today, and then maybe we can get into some more of the details from there.
Sure, sure. So initially, we were here talking about this groundbreaking deal between Disney and OpenAI for Disney to license the use of 200 of its cherished IP characters, environments, props for the use in Sora within the bounded universe of Sora. And of course, that was a groundbreaking deal. Nothing before it had ever happened. Huge for OpenAI. Sora had launched to great fanfare, but then after OpenAI was forced to change from being an opt-out model to an opt-in model when Hollywood went nuts, it was really stagnating in subscribership. And so it presented a huge opportunity for OpenAI to really make Sora into something very special. And for Disney, I mean, Disney was a first mover in this area. And separate and apart from user-generated content, I know there have been a lot of criticism of Disney for lack of engagement with, or lack of kind of a unified way of engaging with consumers outside of the parks. And so this offered a new opportunity to do that and to be the first mover in this user-generated content space. And then, lo and behold, what happened, David?
Yeah, I mean, the deal had been originally announced in, I think, December 2025, and about
I
four
think
months
that's
later,
right.
almost to the day, OpenAI announced that it was abandoning Sora as a standalone app. It was not necessarily moving away entirely from all video generation, but it announced that it was shuttering Sora, and that as a result, this Disney OpenAI deal was being abandoned. And of course, in tandem, Disney announced that they were also withdrawing from this partnership. And so, while the original deal sent massive shockwaves through the industry, really for all the stakeholders, for the studios, for the artists, for the guilds, this announcement was equally shocking, I think, to folks who are following these deals.
Well, particularly here in Hollywood, I think probably less so in Silicon Valley, but we'll get to that as
Yeah.
we talk. I do want to credit us though, David, because we did talk about how the devil is really in the details of hammering out this deal. I mean, from what I've read and from the folks I've talked with, it sounds like the announcement was made potentially a bit prematurely
Hmm.
because there weren't, all the contours of how this rollout would actually feasibly occur were not hammered out at the time that the press releases were made. And so, perhaps that's a learning that we can discuss as we talk through the issues today.
Yeah, I think there's probably a lot of learnings from this deal. And, to your point, I mean, this deal really implicated sort of the crown jewels, right, of the Disney IP universe. And for folks here in Hollywood, it really represented the first time a major Hollywood studio was engaging with a GAI platform in this way. I mean, for the last year, we've been talking about the 100+ copyright suits that have been filed. Disney has filed its own pair of lawsuits last summer, along with NBC Universal and Warner Brothers. And it was really just sort of a groundbreaking partnership. And maybe it's worth just reminding folks who weren't as familiar with the structure what some of the other
Sure.
elements were, because there were some things about this that were really novel and unique.
Sure. And I think that part of that, David, is, what was licensed in this deal and what was not licensed in the deal. So, kind of big picture, a curated library of crown jewels of Disney IP was licensed to OpenAI for use in Sora, about, as I mentioned, 200 characters, universes, cars, props. But very carefully, they did not license for use by Sora any of the images or voices of the actors who portrayed any of these characters. And that was really smart. A number of reasons, and it made the deal a lot easier for Disney because it didn't have to worry about getting clearance from thousands, potentially tens of thousands of different folks who very well may not have wanted to give their rights to OpenAI to have users play around with their name, image, and likeness.
Right. I mean, we're talking about Star Wars and Marvel, so it's Luke Skywalker, but not Mark Hamill, right?
Right,
And
exactly.
and notwithstanding that, however, there was still quite a bit of an uproar from the creative guilds around this as well.
Absolutely, and with good reason, as you said, David. I mean, this was really the first of its kind. And to think about kind of letting go of such control that Disney has asserted over its, very, very valuable IP to folks who would create content. And part of the deal, one of kind of the other deal terms that were announced at the time was that Disney Plus very well might exhibit some of the user-generated content on Disney Plus. And, we've talked about this a number of times. There has been, over the last few years, such a decline in investment in new content to have to worry about a new competitor through this application that created all sorts of different considerations. But going back to the other terms of the deal, there was an exclusivity provision, first year exclusive to Sora, but then not an exclusive for the second 2 years of the term, and certain controls that were discussed where Disney could continue to make sure that its IP was used in ways that were consistent with the ways that it wanted its IP to be out there in the world.
Yeah, I mean, this is obviously a company that's very protective of its brand, right? The family-friendly nature of its content. When we spoke together, we talked a lot about the potential issues that might arise based on users taking this IP and generating their own content. And you had a lot of examples of potential test cases and issues on the margins where things could get very complicated. Of course, we never fully got there because the deal was abandoned. But I think the exclusivity, I think you had a really interesting perspective on it, which was it really gives Disney a chance to engage with this technology, test the waters, but not lock itself in. Although obviously, I don't think they expected to exit the relationship in this manner. But there was one other really interesting component that we talked about also, which was it didn't seem like there was any compensation that was going to be provided to Disney as part of this deal that was disclosed at least, but they
Right.
had an opportunity to invest, right?
Right. That is an interesting aspect of the deal. Disney was afforded the opportunity to invest about $1 billion, with opportunity for future warrants. And in this way, Disney was really banking on the future prosperity of OpenAI and Sora to potentially turn that $1 billion into 100, 200, 500 in the future. And it was really tying the two organizations together. I mean, beyond just the licensing of the IP, Disney also made statements publicly about incorporating OpenAI's LLMs into its workflows across um, the whole organization. And so, really, the two would have been quite intertwined going forward had the deal proceeded.
Yeah, it really created a very interesting alignment of interests between the two companies in that sense, right? And from the perspective of the talent, I think there were a lot of questions raised about, how are they going to be compensated through this model potentially, if at all, right? And I know there were some thoughts about potential claims that could arise from that.
Absolutely. Well, to be seen. I think that Disney has expressed, and I don't want to jump ahead, but Disney has expressed its openness to enter into future deals. And I imagine that it will take the learnings from the failure of this one to make the next deal more of a success.
Yeah, I mean, I think, we'll work through this, but notwithstanding that this deal, didn't hold, let's say, it still has a lot to offer in terms of lessons and precedents and novel structures that are being adopted. I think from the perspective of the big Hollywood studios more broadly, it was really an opportunity to show the market that there is a way to responsibly engage with, first class IP content between the studios and the GAI companies. I think that in and of itself was a tremendous movement within the market.
Certainly. And I think part of the deal, and this goes back to the deal terms, was that Disney was very clear that it wasn't licensing the use of its IP for training. It was simply for outputs, and that helped preserve Disney's position in those ongoing copyright lawsuits that you mentioned earlier.
Yeah, I mean, we talked about this a little bit, not to get too deep into the weeds, right? But within all these copyright infringement cases that have been filed by various IP owners across the media landscape, there's this distinction between the inputs and what the underlying IP is being used in terms of what the models are training on versus the outputs that are being generated in response to the prompts.
Right. And under this deal, Disney said no training, but outputs are okay.
Right, right. So we can talk a little bit more about how that may have affected the litigation landscape, but maybe we can just sort of move into what we know and what was announced in terms of why this deal was abandoned. I think we touched on it a little bit, but what did OpenAI sort of say about this when it made this massive announcement?
Well, publicly, OpenAI has really blamed its limited compute power, and it had to make a tough decision to allocate its resources more towards enterprise and coding type products as opposed to focusing more on Sora. I imagine this is not my area because I'm no technician, as you saw earlier today. Creation of these videos with the audio, I mean, they're beautiful. That must take a significant amount of compute power. And then building on top of that, whatever guardrails are necessary to make sure that users are complying with the terms of use for this IP and how they're exploiting it potentially outside the universe of Sora. It must have taken quite a bit of compute power. And given other public statements about OpenAI's desire to compete in the marketplace with Anthropic's products, among others, I think they had to make a hard decision. I actually heard that one of the executives at OpenAI, a week before the Sora deal, a week before they terminated Sora, said, you know what? We gotta no more side quests, guys. And so I think that statement is somewhat illustrative about how OpenAI might have been thinking about this particular deal, despite the fact that it had an outsized impact on Hollywood.
Yeah, I mean, there's so many interesting things to unpack within there, right? Because we sort of, from the Hollywood perspective, look at this deal as sort of Bob Iger's last sort of crowning achievement, right? When he was at Disney, it was a way for him to engage with the GAI community and really position Disney as a leader within this environment. Um, and from the perspective of studio lawyers, right, and transactional lawyers here in town, abandoning a relationship with Disney and having a conflict with that studio is certainly not something that anybody wants, right? They're such a dominant player within the ecosystem. But I think if you say to yourself, like, who's in a position where they could say to Disney that their side quest or that this type of deal just can't be a priority for them due to other important limitations, and it really says something about the relative market share of these different companies.
It sure does. I mean, it's by orders of magnitude. My last look at Disney's about a 170, $200 billion company, but OpenAI, it's valued at, 840, $850 billion. It's
Incredible.
hard for regular folks like me to really
I mean,
wrap my mind around that.
I'm with you on that. And of course, we talk about $1 billion investment by Disney, and obviously that's tremendous commitment of resources. But right, it's less than 0.5% of the value of a company like OpenAI. But I think you also touched on something really interesting as well, which is that Disney is a legacy IP company. OpenAI is a hyper growth tech company, and it seems like there's almost an inherent incompatibility between what the two companies were trying to do within the context of this deal and how their businesses work, right? I mean, and maybe you want to expand on that.
Or I agree with you, David. An incompatibility with execution. I mean, if you just take a look at like the initial Sora rollout and how the approach was really to, you know, take risks and deal with the outcome later by their approach to, okay, well, we're going to let, all IP be available and you have to opt out of use of your IP on Sora. And as I mentioned before, Hollywood went nuts. They revise, but they're nimble in that way that they can make those types of pivots quickly. Whereas Disney, as foundational Hollywood stalwart, is not the type to jump first and calculate later. And I think you're right, absolutely right, that there's a fundamental incompatibility with kind of the character and ethos of those two organizations.
Well, and when you look at it from a licensing lawyer IP entertainment perspective, you've got a license agreement that's put in place and it's constrained and it has controls within it, and it's a highly sort of consent driven environment where Disney has control over how its IP is being used, and they want to sort of create the rules and then have them in place moving forward, right? Whereas you look at someone like OpenAI, and they're in an industry where things are just changing at such a rapid pace from a quarter to quarter basis. I mean, one of the things that happened after the Disney OpenAI deal was announced, and you mentioned this already, was that Anthropic launched Claude Cowork, right? And I mean, the introduction of these agentic AI tools in early January of 2026. I mean, we're talking just a few weeks after this was announced, all of a sudden completely changed the landscape of what we're talking about. It changed the software as a service industry as a sector. I think the stocks dropped maybe 20% when this was launched. So we talk about a refocusing of priorities and the use of compute. I mean, it's hard to imagine that things could happen this quickly, but that's the environment we're in.
It is. I hear that folks who work up in the valley in AI, that 1 year, every day is like a year. And I don't doubt it.
Yeah, yeah. And when it comes to compute, I heard a really interesting statement from Jensen Huang, the CEO or the head of NVIDIA, talking about when they are evaluating software engineers on an annual basis, what they're looking at is their compute, right? And they want to see that these people are actually using a tremendous amount of compute because that means they're doing something. So it's a really different perspective, I think, on creation. It really is about market velocity, right? Sort of putting pressure on an existing template. But one thing I wanted to ask you about is, one of the things that was so important from the industry perspective was that, Disney, I think, in entering into this deal was acknowledging that they want to meet users where they are, right? And this is about the creation of user-generated content, engaging with users across various social media platforms. Disney has announced after, Disney has said since Sora was shuttered that they still want to pursue these types of relationships and explore it. What's your perspective on how they might go about doing something like that?
Well, I think if I were Disney, I would probably be looking for opportunities to do this on a slightly smaller scale and potentially within more bounded universes so that there weren't so many open questions about um, how to control the use of the IP once it's unleashed to users around the world. I don't know exactly what that looks like, but perhaps contracting with you know, well, for example, and this isn't exactly analogous, but I think that it might be kind of a middle ground or a place that Disney might spend a little bit of time before re-engaging. Disney entered into a deal in 2024, and this was actually a D'Amato deal. It was not an Iger deal, with Epic Games to create basically, as far as I understand it, Disney universe within Fortnite. And so that's a way where Disney can have more control about the way that its IP is deployed in this universe within Epic Games, but it still gives users an opportunity to engage personally and have agency in interacting with the Disney IP.
Yeah, I mean, it kind of goes back to the point we made, which is it's very different from sort of the fast-moving, scalable world of OpenAI and what they're trying to do, right? It's really more of a closed universe, it seems like.
Exactly.
Yeah, I mean, I think it's a fascinating environment in terms of how these companies are going to engage with fans and start dealing with these issues like at AI scale, as we've said. Uh,
One point I wanted to get your input on, David. I heard that there was a Sora policy document that was issued, I believe internally, just days before they announced the closure of Sora. And I'm so curious about what was in that document because presumably that must have set out the rules of the road, at least in more detail than anything else that's been publicly released as far as the guardrails that we talked about in our prior podcast and today, ownership of the content created by users and potentially, rules about how that content can be exploited downstream.
yeah, I'm not familiar with what was in there, of course, but one observation is, more and more we do see companies like Netflix and other companies out there issuing policies about how they are going to engage with AI, how they want their users to engage with AI, the content providers to engage with AI. I think within a Sora context, I mean, I think the issues were, to your point, to what degree are users going to own any of the content that they create, right? And as entertainment lawyers who do rights deals, for example, we always think about, okay, what's the original content? What's derivative of that content? And under the Copyright Act, that's going to be owned by the original creator. But what are the things that might be are original? And can those things be parsed out, right? And can they be used in a different context? And I'm
And
sure,
if they're not, if there's not human creation, can there be copyright protection for them? It raises so many issues.
yeah, so many challenging questions. And I wondered to what degree they were thinking about, you know, how exploitation of this content might lead to issues with the guilds and some of these issues we've talked about in terms of artists who contributed to this content having potential first negotiation rights and the opportunity to create derivative works and how it would affect potential definitions and if there's any way to monetize this content. So a lot of weeds to be sifted through. It seems that we're not going to get answers on them at this point. But one thing I wanted to ask for your opinion about, as an expert litigator, of course, is what do you see as sort of the potential implications of this deal for the ongoing generative AI litigation that's happening? And from my perspective, from the big picture, we know that once the deal was announced, it spawned various types of discovery and other things that were going on in these cases. And so there's been these downstream implications for a deal that ultimately didn't hold, right? So it's created all these issues without the potential upside, it seems, for the parties who are involved.
Absolutely. On that discovery point, I actually took a look today because we talked about this in our last chat about this, and there had been a motion to compel in the in re OpenAI copyright infringement cases that are going in New York right now. And it looks like it was brief. There was a hearing, the court ordered further meeting and conferring, and then Sora went away. But it was interesting to look and see what the plaintiffs were arguing as to why the discovery of information about the deal was relevant to the lawsuit in New York. And the plaintiffs basically were arguing three different elements of relevance. First, they said it was probative of the commercial purpose of OpenAI's use of the plaintiff's works to train LLMs. And basically, I think on that point, they were saying, look, there is a commercial marketplace for this type of content. And, lots of money obviously exchanged hands in connection with this deal. And this deal is probative of the purpose that OpenAI trained using our content, obviously, to make, to participate in this marketplace that's worth billions of dollars. Second argument was that it was probative of the fair use factor 4, which goes to the marketplace itself. And they argued that the feasibility of OpenAI entering into the licensing market was proven by the fact that it had entered into the licensing market for this content. Of course, it was licensing this content for outputs as opposed to training, but the argument still was at least, I think, a colorable argument. And then third, there was an argument that this evidence went to OpenAI's willful infringement. If it knew that it had to enter into this license agreement with Disney in order to use the IP on Sora, then it certainly knew it had to license the content from the plaintiffs in those cases in order to use it for training its LLM. So
Has the response been briefed? What does OpenAI say in response?
basically, OpenAI's response is, well, it's not responsive to any of the discovery requests that you already served. And we don't think it's actually relevant because you're talking about a license of Disney's IP as opposed to licensing a plaintiff's IP. Plaintiff's IP is largely just text and audio, whereas Disney's IP is visual. So there are distinctions, and it's yet to be determined how the court there rules on this issue. But I do think that the court's ruling on this motion to compel will be a bellwether of how this deal, be it a failed deal, is used in the future litigation on the merits as well.
Yeah, it's interesting because I've been at seminars here, for example, at UCLA, where a gentleman from OpenAI who sort of runs their partnerships initiative has been on stage, and they try and sort of thread this needle and say, we do believe that we're entitled to do what we're doing and that it is a fair use, and we don't need consent to do this. But we still want to engage with all these companies and we want to work with them collaboratively. And we think there's a win-win situation here where we can create a better product, provide a better user experience, and have everyone participate together. So I imagine if and when they get to trial, there might be some of that going on in terms of the arguments. But to your point about the market analysis, what it makes me think about is the Kadri versus Meta case. And of course, you're familiar with Judge Chabria's ruling, where he talks about the potential market dilution quality of these usages, right? And a lot of commentators have talked about the novelty of this theory, but the general idea was that the plaintiffs haven't demonstrated that the failure to license their works and to create this sort of avalanche of new content isn't diluting the market, right? And so I think there's a new piece of evidence here potentially to talk about when it comes to that as well. How about the Disney Midjourney case that's still going on right now? I thought that it was very interesting that, just to set the stage, Disney and Midjourney Disney sued Midjourney last summer along with NBC Universal, and then eventually Warner Brothers joined that suit. Um, and it was a similar concept, right? They're training without authorization, and they're creating these infringing outputs without authorization. Um, a subsequent suit was filed by Disney, NBC Universal, and Warner Brothers against a platform called Minimax and a Chinese company called Hailu, I believe it's pronounced, with the same kind of theory, except they're based in China. Um, what do you think that this deal suggests might be signaling in terms of a potential framework for a mediated resolution of this case, or or is it not going to be helpful to the parties either way? If you look at the docket, I think there's a mediation that's been agreed to, at least in the Midjourney case.
That's right. We talked about this a little bit, and I think that folks you've talked with, folks I've spoken with, what I've read is that there's no amount of money that's going to cause these lawsuits to go away. It would really require a modification of the product itself. And so if the Disney Sora deal were to be of any um, example that could be useful in getting towards a mediation, and I don't know how possible this would even be at this point, but were Mid-Journey to change its product such that it's no longer trained on the IP and it goes through a process of licensing specific IP for outputs, maybe there's a path forward. I think it's going to be tricky, obviously. Um, and I think that the damages or compensation piece will be different because neither neither of the parent companies necessarily have the same type of future market potential that OpenAI does. And so I don't know that the $1 billion investment in the Disney Sora deal will be instructive as to what's the right compensation number or how to structure that. That'll be interesting to see if they're able to, make headway in that way.
It does create some type of conceptual framework, at least, for how
Right.
they might be able to work together. I always thought um, that it would be challenging for them to reach a settlement that would allow Midjourney to potentially uh, in, engage in generating these outputs when you've got this OpenAI deal in place that already had exclusivity provisions in place, right? So I thought that might be an obstacle, but I guess we'll see how that goes. So, uh, maybe sort of what are a few key takeaways? What do we think in terms of lessons learned from this deal? What comes to mind for you as if you were going to advise the companies on things to think about moving into this type of licensing landscape in the wake of this announcement?
Well, this goes back to something we talked about at the outset. Proceed with caution and potentially wait to do a public press release of a deal until the full contours of that deal are hammered out. I think that Disney and OpenAI could have avoided a fair amount of public fallout had they done that, as opposed to making the announcement first and then figuring out the devil in the details afterwards.
Yeah, I mean, I think it's think hard about who you're working with, right? I mean, you can't fault Disney for choosing to work with OpenAI, obviously, but Sora was a relatively new product as well, right? And I
Right.
think in some sense it's a cautionary tale for all these companies in terms of being careful about where you're making commitments, obviously, and maybe thinking about what those exclusivity provisions should look like, or maybe, I kind of thought a year's not that bad, right? And going exclusive after that, I wonder if they would be rethinking that sort of consideration as well. And I guess the other thing I would say is think about sort of the backlash, right? I mean, there was a tremendous response from the talent community about this. We're in the Guild renegotiation season right now. Obviously, the WGA has just announced a deal. I'm not gonna feign familiarity with those terms just yet. I think they were, I don't know if they've even been fully
No,
disclosed yet.
I don't think.
But I got to imagine it's probably an important lesson here for the companies about how to engage with the talent community around these deals.
I know there was some engagement before the announcement, but I agree with you, David, that there needs to be more, and that could kind of alleviate some of the fallout that we saw around the announcement of this deal.
Yeah, I mean, I think that it kind of takes us back to, I think, one of the central tenets of what this conversation has looked like, which is clearly, these types of AI technologies are not going anywhere, right? There is tremendous opportunity that they present within the Hollywood community and more broadly. Um, but there's also a lot of concerns that we've talked about, right? And there are these tensions that exist, and it fundamentally always comes back to the question of what is the responsible way to engage with this technology and to keep in mind the competing interests. I think this deal is a reflection of an effort, I think, to try and keep that question front and center.
This is something that we talked about. I don't know that it made it in the podcast last time, but this Disney Sora deal was sort of like a creation of a crosswalk where previously the generative AI companies had been jaywalking, for lack of a better term. And here was a crosswalk. They were bounded space where they were within the rules by licensing IP to use it. And despite the fact that the deal went away, I do think that by blazing that pathway, there is a model going forward of how these generative AI companies can work with Hollywood studios.
Yeah, I think it's a great point, and it's a great framework to use to think about this. So I think we're at the end of our time for today. Julia Cherlow of Bird Marella, thank you as always for joining me. It's fantastic to have this conversation with you.
David, it was so much fun. Thanks for including me.
My pleasure. And I guess we'll see. Maybe we can get together for the next major announcement like this, and we'll see where things head.
I can't wait.
Thank you very much.